Welcome back. Let's continue to this now. The uMkhonto weSizwe party has filed urgent papers in the Gauteng High Court in Johannesburg to interdict the October Judicial Service Commission sitting. This after its request to postpone the sitting was not acceded to. The JSC resolved to continue with the sitting schedule to take place from the 7th until the 11th of October 2024 without the MK's Dr. John Hlophe, citing that the JSC remains lawfully composed and that Hlophe's absence would not render the JSC's decision or processes unlawful. Hlophe has been temporarily interdicted from participating in the JSC pending the review of his designation to the Commission. Our legal analyst Kevin Smith joins us now via video link to weigh in on this interdict. Kevin, a very good afternoon to you and thank you so much for your time. Well, a number of developments then, to this point and this moment. This development following that letter written to the JSC by uMkhonto weSizwe, party seeking a postponement of the next sitting in October, which was denied, of course, but that followed an interim interdict, which was granted by the full bench of the Western Cape High Court, which halted Dr. John Hlophe from participating in these sittings in October. In fact, next week, pending a review then of his designation to the JSC. I mean, what do you then make of this latest development by the MK party? Are there any grounds and probably prospects of overturning the High Court ruling?
Look, I think what we need to bear in mind is that the current interdict is on the basis that they are looking for the full bench's decision to actually be reviewed. So what both sides are looking at is that they want those deliberations to take place. They want that adjudication to happen. It's just that the functioning of how the two interdicts are looking, that's where we have the difference. On the one side, that the full bench are saying that it is easier or most practical to have Dr. Hlophe interdicted from participating. And on the other side, you'll see that Dr. Hlophe's interdict, along with MK's papers, are saying that it would be better to interdict the entire proceedings themselves than to bar him from participation. But outside of that, both parties actually want the JSC's appointment to be deliberated upon, and they do want either the review application or the Court decision to come into effect before these matters actually take full effect in themselves. So what we're looking at is that the parties don't disagree that the deliberations should happen. It's just that how the interim proceedings need to take place is where we differ. On the one side being that it's easier or more practical for Dr. Hlophe to be excluded. On the other side, they would want the JSC in itself to have either a full postponement or for them to have the proceedings themselves interdicted.
On the basis of urgency and just looking at your reasoning and the various scenarios, what then can we expect to happen?
Look, in the interim, until this current application by the MK, if an order is granted to that effect, the previous order by the Western Cape High Court remains in full force and effect. So to the extent that that isn't in the interim or by virtue of this new application overturned, Dr. Hlophe will in fact be interdicted from participating in the upcoming JSC sittings. And one thing that we have to bear in mind is that an argument is made that the initial court, being the Western Cape High Court, had stated that the decisions of the JSC won't be materially impacted, which makes it an argument of quorum. Whereas the MK are saying that the issue isn't on the quorum of the JSC, but on it being constituted itself. And what they mean by that is that the Constitution sets out how the JSC must be constituted. In this instance, saying that there must be 6 members from the National Assembly, 3 from opposition parties, and 3 from the government itself. And what they're saying is that Dr. Hlophe not being allowed to participate means that the JSC won't have been formally constituted. So regardless of whether a decision is made via a quorum, they're saying that the constitution itself of the body would be unconstitutional, meaning that the decisions that they then make or the deliberations that happen on October 7th would then also become tainted by the same unconstitutionality, meaning that they would then have to unscramble that egg at a later stage. So the issues here are interpretation issues. In the first instance, the Western Cape High Court had said that Dr. Hlophe's or his absence rather, would not materially impact the functioning of the JSC, whereas the MK are arguing against that, saying that it's a matter of the JSC being constituted formally or constituted via the relevant constitutional provisions.
And I mean, it's interesting that you say that, particularly when we look at the JSC, in its reasoning to want to continue the sitting without Dr. Hlophe, saying that it remains lawfully composed and that Hlophe's absence would not render the JSC's decision or processes unlawful. I mean, what's your take on that?
Look, again, I think where that takes us is on what period of the timeline are we looking at this matter being tainted? Are we looking at it further down the timeline, being after the JSC has already been constituted and they have their first sitting? Or are we looking at it a bit earlier on the timeline when the National Assembly had to make its decision in actually allowing Dr. Hlophe to be appointed in the first place? Now, if we think about it, the Western Cape High Court had stated that the National Assembly had failed to exercise its discretion in allowing Dr. Hlophe to be appointed, stating that his appointment shouldn't have just been rubber stamped, but they should have exercised a level of discretion in saying that should an impeached judge actually form part of the JSC. And the reason for that is that the JSC isn't just a normal portfolio committee, but it's a portfolio committee that has to make decisions based on the judiciary itself. And because the judiciary itself serves a very important public function, it's not just the rights of the members of that portfolio committee that come into question, but it's the rights of the citizens, because the judiciary has an important function for the citizens themselves. And what they did, in fact, mention is that the appointment of Dr. Hlophe onto the JSC, it might erode public confidence in the JSC itself or in the decisions of the JSC, which is a very persuasive argument to make, because we can state that having someone who has been impeached and being found guilty of misconduct could then bring into the public perception of what the JSC is doing, and it could erode the public's confidence. Hence why the Western Cape High Court felt it necessary to make that interdict, not on the basis of them finding that it was wrong for the National Assembly to appoint him, but just to say that in the review application that still has to come, or the Constitutional Court decision that still has to come, whichever comes first, those deliberations are important for us actually to influence what decision is to be made thereafter. So that interdict isn't on the basis of the merits of them saying that it was wrong for Dr. Hlophe to be appointed in the first place, but it's just them agreeing on the fact that there is something that needs to be said, there is a case that needs to be answered, and this has to be deliberated upon. And in their viewing, it was much more practical for them to then disallow him from continuing with his functions at the JSC than to rather interdict it as a whole.
All right. Thank you so much, Kevin, for that breakdown for us. Kevin Smith is a legal analyst, of course, on the back of that particular story coming out today. Of course, the uMkhonto weSizwe party filing those urgent papers in the Gauteng High Court in Johannesburg to interdict then the October Judicial Service Commission sitting. Those are due to begin on the 7th of October.